Hi viewers, welcome back to our channel. We are sure you must have learned something from the first video in this series, which is teaching you defenses to criminal charge in case you are charged with any alleged commission of offense. In the previous video, the first of this series, we taught you about the defense of alibi. We explained alibi and the ingredients and the materials you will need to prove the defense of alibi. In case you have not watched that video, log into our channel. That video is there. You will have a lot to learn from it. We'll continue in that series. Today is the second episode, episode 2, where we'll be teaching you about the defense of provocation. My name is Ishaku Joseph Shirme, Abuja-based lawyer, bringing you different topics so that you have a complete and comprehensive understanding of a lot of the things you hear lawyers say and you hear about judiciary and the cases going on in court and the rest. We want you to have a comprehension of it. That is why we are making these videos, to break down law terminologies for you to understand. So today on the topic of provocation. Now the provision of Criminal Code section 284 made provision for provocation. Now how does provocation work as a defense to criminal offense? In the issue of assault, the provision is that a person will not be criminally liable for assault on the person who provoked such an assault from him. Now, what does that mean? We have offense known as assault and battery, that is physical attack on a person. If a person provokes that attack, there can be a provision, there can be a way a person will raise that as a defense. Now, how does this work? Let's say the law admits the fact that a person can be put in a situation where you will lose sense of self-control. Now, assuming you just came back from work, entering your house, your sitting room, and you met your wife with another person in a very compromising situation. It is very common that you see a person may lose his sense of self-control and give an attack. Or let's say you and your aged mom are walking by the road, or you just entered into a place and before you know, a young man just came and landed her a terrible slap. Now in situations like this, it is assumed that it is very possible a person will be deprived of his self-control and give an attack or possibly a reaction. There are times we have done something that before you know, by reflex, by impulse, and then before you know it, you sit back and regret. Now, these are the instances of provocation that the law will make excuse for you. However, there are salient things you need to note. The defense of provocation will not avail a person who must have taken time from the time or the provocation is said to have taken place. If you take a time when the law will have expect you to have calmed down and reason yourself before taking that action, the defense of provocation will not avail you. Now let's go back to the example we gave of a person either meeting your wife or your spouse in a compromising position, and then after seeing that, you took a step back, went back to your car, brought out a weapon, a gun or a knife, and then you came and attacked with that. Now, the assumption of the law will be that taking the time to have reasoned what weapon to go and pick, how to come and organize your attack, it will be expected that you have gotten enough time to have cooled down and do this. Now, the basis for this defense of provocation, when you are establishing a criminal offense, the burden on the prosecution is to establish what is called mens rea and actus reus. Mens rea means the intention to commit that act, and then actus reus is the actual commission of that offense. Now, what defense of provocation will do for you is to satisfy the fact that there was no intent on your part to cause the resultant effect of your action. So if you are assuming by the provocation you were provoked and you launch an assault on another person, and that resultant effect of that, assuming the person died, this person slumped. Now, instead of being charged for murder, if the actus reus is not there, you may end up being charged for manslaughter, because the loss of your self-control, the provocation that deprived you self-control, will take out the portion of that mens rea. Will prove to the court that there was no intention for the consequences of your action. So basically, the defense of provocation is to say the person put me in a position where I lost self-control and did what I did. So if there is so much gap and space for you to have calmed down, for you to have cooled down before you reacted, the defense of provocation will not avail you. So make sure you follow up on our video, and we will get the one we will talk about the defense of self-defense, so that you'll be able to get the clear-cut difference between the defense of self-defense and then the defense of provocation. Thank you so much. Continue to follow up on our series. We will talk about all the defenses that are available to a person who is being charged with the commission of an offense. Thank you, and we'll see you in our next video.